before we proceed? Okay, there's some people that has, there's some sounds in the background. Can you just all mute yourselves, please? Are they, unless you have a question, then you can ask me.
Good evening,
Can you hear me
Advocate.
clearly?
Yes.
And I'm sharing with you, am I not?
Yes, you are.
Okay, good.
I just want to ask a question, please.
Yes, you may.
I just want to know if the rules are amended, how quickly does the amendments become available? Because I've noticed on some of the pages in the guide, there's referral to rules that's not in the amended rules that I have.
Okay, what guide are you talking about?
The guide that we're using, the High Court Practice
Okay,
Guide.
and what amendments? There's amendments that have now recently come into operation. Are you speaking about those amendments?
No, it's just something that I've noticed. Like in the case of the declaration, where they explain about what the declaration is, they refer to a rule 32 bracket 8 capital A, and that is no longer in the rules. So why are they
No,
referring?
it has never been in the rules. That is a mistake. Because with
Oh.
default judgment is Rule 31 and not Rule 32. It has never been Rule 32, so that is a typing error.
Okay.
But you are correct when you say that your guide is not updated, because remember that guide was printed, that version that you have, I think, was printed last year. So there has been amendments now, and that wouldn't reflect in your guide. So it is incumbent upon you to update it with the latest rules. I mean, you're a lawyer. You can find what the latest rule. If I tell you, or if I don't tell you, but I'll try to tell you where I know that it has changed, then you must just amend your guide accordingly.
Okay, that's fine. Thank you so much.
It comes into operation on the date on which the government gazette, in which it is promulgated, in which it's announced. It comes into operation on that date. So it is usually published before then, but it will come in operation on the 1st of June. I think that the recent amendments came into operation the 22nd of June. I speak under correction, but it was published in May already. So if that is part of what you're worried about or what you're asking.
Yes,
Okay.
Thank you, Advocate. Thank you.
Okay, sure. Right. So we stopped with default judgment yesterday. Are there any other questions on default judgment? Did you also notice that typo of where they refer to Rule 32, and in fact it is actually Rule 31 that deals with default judgment? So tonight we are going to deal with default judgment. Sorry, a correction. Tonight we are going to deal with Rule 32. Yeah, that's what I wanted to say. Tonight we're dealing with Rule 32, and Rule 32 is the summary judgment application. Now, for those of you, like you did on your first night, remembered everything that you did in match court, you would remember this as Rule 14, but the content is exactly the same. So if I'm boring you, I'm sorry about that, but I have to do it with you. Okay, so summary judgment. When can you apply for summary judgment? There are 4 instances in which when you can apply for summary judgment, as you would know. Right, so those 4 instances would be if a claim is based on a liquid document, or for a liquidated amount in money, or for delivery of specified movables, or for ejectment. In those 4 instances, if you issued summons, whether it was a simple summons or a combined summons, you issued the summons, right? It was served by the sheriff on the defendant, the defendant files a notice of intention to defend, right? He files his plea. Now you look at the plea, and in your opinion, there is no defense made out in the plea. Then you can apply for summary judgment. Okay. So you must look at the plea, and then you bring an application. And in your guide, there is an example of a summary judgment application on page 105. Starting on page, on page 104. You will see if you are on page 104 of your guide. Please take notice that that is what the summary judgment application looks like. Okay. So you would bring an application for summary judgment if you are of the opinion that there are no defense that is triable. No, what he's talking, even if he proves that it's not triable. Right. So you do it with in 50th the plea. That is the amount of time you have. It is the same amount of time that you have if you wanted to file a replication. But now instead of filing a replication, you opt to file a summary judgment application. Now, sorry. The notice of motion and the affidavit. There's an example of the notice of motion. I don't have an example of the affidavit, but this is what you must set out in your affidavit. You know, the cause of action. So you would basically say in the affidavit, obviously, I, the undersigned, do hereby state under oath, and all of that you start an affidavit with. Then you will say, I verify the cause of action as it is contained in the summons or in the particulars of claim, depending if you use a simple summons or a combined summons. You would say, I verify the amount claimed therein. You would say the amount of and that. Then you will identify any point of law that you rely on. It was a contractual or whatever point of law you rely on, you identify that. And then after that, you would identify the facts on which your claim is based, and you will explain to the court briefly why you are of the opinion that the defense that the defendant has pleaded does not raise any issue for trial. So you would raise that. Okay, so now you've got your application for summary judgment. It's in court. You serve it on the defendant. So if you're now appearing for the defendant who comes to you and say, I've received this summary judgment application, what can the defendant do? The defendant can do one of two things. The defendant may either provide security to the plaintiff to satisfy the judgment, including the costs which may be granted against him. Or the defendant can file an affidavit in which he discloses what it is, what is his defense. Now, I'm saying that, but he's already disclosed his defense in his plea, but now he must further explain his defense. Just bear in mind, the defendant does not have to prove his defense at this stage. He doesn't have to bring witnesses to prove it. He will just have to set out the facts on which he says this is a defense that I have. The other option, and many defendants don't use the first option by paying the amount claimed plus cost, or not the amount, but for that. Remember, security doesn't have to be money. It can be any movable, valuable thing that the defendant can tender, and that this will be available, and then he is allowed to continue in the trial, and the court will have to adjudicate on it. That is what that is. You will give security, or he can explain his defense in an affidavit. Right? You don't lead oral evidence, but if you feel it is necessary, you can bring an application to lead oral evidence in the summary judgment application. Right? When you set out your defense as a defendant, you must set it out fully. You can also raise a counterclaim to the plaintiff's main claim, right? And no replying affidavit is allowed. So you start off with a summons, a particular soft claim, or just a simple summons. And remember, you can only do it in those 4 instances. You cannot bring a summary judgment application for something else. It must be on those 4 instances. Then you do the affidavit where you verify the amount and all of that. You say why the defense is not triable. You go to court. If the defendant has filed an affidavit, he must then convince the court that he has a defense, and that if the defense is proved at a trial, he may be successful. That is how the court looks at it. So should the court give then leave to the defendant to proceed with his defense? So, for example, the court says summary judgment is not granted, is dismissed. The summary judgment application is dismissed. That means the plaintiff doesn't have judgment. So then the defendant can continue with his defense as he was started. You will continue then. The plaintiff can then file his his replication, and then you conduct yourself further up until the end. If the court grants summary judgment, then that is the end of it. Then the plaintiff goes away with his full judgment without having to have run a trial. Okay. Now, if the plaintiff knew that the defendant relied on a contention which would entitle the defendant to defend, the court may order that the action be stayed until the plaintiff has paid the defendant's costs, and may further order costs to be taxed between attorney and client. Also, where the court finds the defendant raised unreasonable defense and resisted the summary judgment initially. What I'm saying there is that if the plaintiff can see that there is a real defense and he still brings a summary judgment application, the court can punish him. If he ought to have seen, but this is a defense that is triable, he's talking nonsense when you say there's no triable defense, then the court can make a cost order, a punitive cost order on attorney-client scale. The court can also order, to make it worse for the plaintiff, that you cannot proceed with this action until you have satisfied that cost order. So the proceedings will be stayed until the cost has been paid. The court can do that. Likewise, if a defendant knows he doesn't have a defense and he still resists the summary judgment application, the court can also make a punitive cost order against him. But the defendant is already going to get the cost order against him if this plaintiff is successful with the summary judgment application. But if the plaintiff was now really willfully wasting the court's time, and he knows that he doesn't have a defense, the court can also make that cost order punitive. Right. This is different to what it was in the past. Before 2019, it changed in 2019, this rule. To the effect, before 2019, you could apply for summary judgment after the notice of intention to defend. And if you were of the opinion that it's a delaying tactic and they're just buying time, they really don't have a defense, then you could bring summary judgment application. Now, since 2019, the Rule 32 has been amended. Now you must wait until you receive the plea from the defendant and then see in the plea whether, according to you, there's any triable issue in that defense. If not, then you can bring summary judgment application. Okay, do you all understand summary judgment? I don't have to. Are there any questions?
Advocates, hi.
Yes.
For purposes of our exams, would we need to know what the old position was versus what the new
No.
position is?
No,
Okay.
that was just interesting.
Okay.
They won't ask you what was the law before. I mean, what you're never going to apply it. So are you saying I shouldn't have mentioned that?
No,
You don't
no,
want to hear history.
no,
Okay.
I'm just intrigued because you mentioned it and other lectures have mentioned the old position, and I just thought, do we need to know that as well? Thank you.
No, you don't need to know that. You don't need to know that for the purposes of the exam. It was just it's just so recent. That's why I'm mentioning it. Well, it's probably not that recent. 1919 is it's now 4 years ago. But I think the reason why I mentioned it was COVID, and we didn't react for some time, and things weren't normal. And here we are. It's like it was yesterday that it changed, but it wasn't yesterday. It was in 2019. Okay. So forget that what I said before, the history of summary judgment. Now you have to wait for the plea, and then you apply for summary judgment. Okay. Right. What slide are you on now? I am now confused. Oh, yeah, there you go. I have two laptops open and I don't know which one I am. Yeah, okay. The summary judgment, if the claim is based on a liquid document, you must have a copy of the liquid document, and it will be set down 15 days from the delivery of the application. Right. Right. What must be in the brief, that you can just read up. That is not important. A lot of attorneys go to the court themselves, but you will know what must be in the brief, so you can just read through that. I'm going. That was rule 2 of the uniform rules, right? Summary judgment. We did rule 31, which was default judgment. Now, part of rule 31, if you've read rule 31, also deals with a confession to a judgment. Now, a confession to a judgment is when the defendant says, look, the court can give judgment against me. I am liable for this, and I don't have any problems if the court gives judgment against me. So confession to a judgment is a confession made by the defendant, and the confession is signed by the defendant. Now, the signature of the defendant must be verified by the defendant's attorney. And in the case where the defendant don't have an attorney, he must depose to an affidavit to say that, look, I verify that the signature on the confession is mine. But the plaintiff's attorney cannot verify his signature. Okay. And the advantage of this is it is the plaintiff's attorney then apply for the judgment. He writes a letter to the registrar, and then a judge will give the judgment in chambers and not in open court. Okay. So that is what confession to judgment is. That is when the defendant says, look, yes, I owe this money. The court can give judgment against me. I suppose you would save the court costs, keeping it out of court, because the plaintiff's attorney writes a letter to the registrar, and then it goes to the judge in chambers, where he will then make that judgment an order of court. All that must be is the confession signed by the defendant, and then his signature must be verified by his own attorney. If he don't have an attorney, he must depose to an affidavit wherein he says the signature on the confession is mine. Right.
Hi, Cricket.
Yes.
Can it also be called consent to judgment? Is it the same thing?
Yes, it is. But the rule says confession to judgment. What does the rule say? Consent to judgment. Let me just check. Just hold on 1 minute. Just get the rule. 31. Yeah, judgment on confession. So the rule talks about confession. Rule 31's the heading is judgment on confession and by default and rescission of judgments. So it is confession, but some people would refer to it as consent. Okay.
Thank you.
Okay. Right. If there are there other questions on confession to judgment? Right. Let's move on. Now we've talked about the plea. We know, we said in the beginning that the two most important pleadings are the particulars of claim and the plea, because from those two documents, from those two pleadings, we would be able to ascertain what it is that the parties are fighting about, right? And how do we ascertain? We look at what the defendant pleaded and see with what he is in agreement and what he is disputing, right? Now, before you plead to the merits of the case, the merits would be the allegations made by the plaintiff, those merits. Before you deal with that, if there are circumstances for a special plea, you can plea a special plea also. Now, a special plea has got nothing to do with the merits of the matter. It is something outside of the merits. There's two kinds of special pleas that you get. You get a dilatory special plea, and you get a special plea in abatement. Now, a dilatory special plea, an example would be a special plea of arbitration, a special plea of lis pendens, a premature summons, or a non-special plea of non-joinder. And a special plea in abatement would be prescription, res judicata, and absence of jurisdiction. Right. Now, an example of when you would raise a special plea of arbitration. When I say dilatory, I mean it will just delay the proceedings. It doesn't bring an end to the proceedings. It delays the proceedings. Say, for example, the parties had entered into an agreement and the dispute has something to do with that agreement. It's about that agreement. And one of the clauses in that agreement says, it's an arbitration clause, it says, should a dispute arise between the parties, then we will first go to arbitration before we go to court. And in a case then when one of the parties receive from the other party to the contract a particulars of claim, a summons and a particulars of claim, he can then raise a special plea of arbitration. He will say, we've entered into the agreement in clause so-and-so of the agreement. We have agreed that before we go to court, we will first take the matter on arbitration. The plaintiff did not take the matter on arbitration, and therefore the proceeding should be delayed until that is complied with. That would be the special plea, delaying the process. So first they must go to arbitration, and depending on the outcome, then only will the proceedings possibly continue. Lis pendens, and I know that you know all of this, eh? Lis pendens is when there is a pending matter in another court between the same parties based on the same cause of action, right? So there's already a pending matter. A good example of this would be the one party institute divorce proceedings in the regional court, and then the other party decides, no, but I'm going to divorce you better, I'm going to the high court. So in that case, you could raise the special plea of lis pendens and say, but we're already busy with divorce action. Why? Oh, there can't be two matters running at the same time based on the same cause of action between the same parties. Right? Doesn't mean you can't have different matters on different causes of action in different courts. That you can. But if it's the same cause of action, the same parties, you can't have it running in different courts, right? Premature summons, that is what we did. The section 129 notice, you must send a notice to complete the cause of action. Section 129 of the National Credit Act. Or the notice in terms of the institution of legal proceedings against certain organs of the State, Act 40 of 2002, that section 3 notice. You must send that before you can issue summons, because if you just issue summons and you did not comply with that, then your summons is premature, because we say you must send a notice to complete the cause of action. And then non-joinder, remember, there's compulsory joinder in terms of Rule 10, where a party who has a direct and substantial interest in the relief that is sought, and that person is not joined, then you can raise a special plea of non-joinder. Then the plaintiff must then bring an application to join that party, explain to the court that this party has a direct and substantial interest and should be joined. And then only once the court gives the order that the person can be joined, then the proceedings go on from there. So it delays the procedure. Right. In abatement brings an end to the proceedings if the defendant is successful with his special plea. For example, prescription. If we know a debt prescribed within 3 years, so if it's a debt based and it's going to prescribe, or it has prescribed, and the defendant raises that, should the defendant be successful, that would be an end, because then you can't go on. That's prescribed. The same with res judicata. That means another court has already made a decision based on the same cause of action between the same parties. So you can't go to court again. And the absence of jurisdiction, if a court does not have jurisdiction to hear a matter, that is, you can raise that special plea. The court doesn't have jurisdiction. This case belongs in another court. And then that is the end of that. Okay. Now, when you raise a special plea, you must still plea on the merits. They say plea over the merits. Are there any questions? Is a hand? Yes? You may ask.
Let's pending this again, because I'm confused. You are saying it's the same cause of action in 2 different courts.
Yes. I'm saying so,
Is
yes.
it, okay, is it different parties as well?
No, I said the same
Or
parties and the same cause of action. Did
The
you,
same
did I not say that? I'm sorry. I said,
Yeah,
I
hence I
meant to
wanted
say it if I
to
didn't say
explain
it.
it again.
Hey?
You did say.
I did say it is the same parties and the same cause of action in 2 different courts, like, for example, a divorce. Because, I mean, there's already a matter pending between us in another court based on the same cause of action, and now you went to this court. Yeah, that is what lis pendens means. Did I answer you sufficiently, ma'am?
Yes, you did. Thank you.
Okay, thanks. There's another hand. The other hand can also ask.
Advocate, the special pleas in abatement, don't they mean that if you raise that plea, then that's the end of it? But I see absence of jurisdiction. If you were to raise that, wouldn't that mean that the plaintiff could now go to a court that would have jurisdiction, other than in an instance where you would have raised prescription or res judicata?
You are
So
correct.
if you raise absence of jurisdiction, then the plaintiff can go to another court which will have jurisdiction.
Yes, he can.
Yeah.
He can.
So, okay.
So that proceedings in that court has ended. It brings an end to the proceedings. He'll have to institute new proceedings.
Or is the end of it in that court?
Yes.
Oh,
It is
no,
killed.
thank you.
That case with that case number is now finished.
Okay.
Because he don't have jurisdiction. Do you understand what I mean by abatement?
No,
I'm not saying he don't have a claim anymore, but he don't have a claim in that court. And then if they go to the other court, the court, you can't raise judicata because that court didn't even decide on that matter. If you go to the correct jurisdiction, the court with the correct jurisdiction. Yeah,
Approve prescription and res judicata, then that's the end of it.
yes. You can't
Oh,
go to a new court that won't have prescription.
Okay.
I hear
No,
what
thank
you're
you.
saying. I can
Yes.
see how it can be confusing when I say it brings an end. Absence of jurisdiction means the proceedings that is now before the court, if you are successful to say this court doesn't have jurisdiction, that claim is dismissed in that court, but it doesn't mean you can't go to another court because the court did not already decide on this was outside of the merits. The court didn't make a decision on the merits yet.
Thank you.
Okay.
Thank you, Advocate.
Yes. Just having said that, there was something I was thinking about now when I looked at that, and now I lost my train of thought. Maybe it will come back to me. I just noticed something. It's had to do with jurisdiction. Can't remember. Right. I will think about it. There's another hand, or is it an old hand? Is there another hand up? I see a hand.
Hi, so my hand. Yes, so my hand is up.
Excuse me.
Yes, so my hand is up. I wanted to ask about the prescription. If, for example, one of the parties, let's say a defendant is saying, I don't have a prescription, and I agree with that, can I still apply for, the court that must at least, my case, give me, let's say, for the condemnation on the very
Just
same
say
court?
that again. Prescription.
All right. Let's say, for example, a defendant is raising a special plea of the prescription, and I agree with that the case is prescribed. Can I then, on the very same matter, apply, make, the condonation on the very same court?
Condemnation for prescription.
Yes, yes.
Okay, just tell me, are you talking about specific facts, or you're talking in general? Because once a matter has prescribed, it has prescribed. You can't ask for condemnation. If it's prescription, what kind of prescription? I'm talking about the date that prescribed within 3 years in terms of the Prescription Act. Are you talking about prescription of something else?
Let's say, for example, in terms of the, the 6 months, when you deal
No,
with
there you can ask for condemnation. The court,
Okay,
that is the 6 months. The court, sorry, not the court, the Act 40 of 2002 says in section 4 that if you did not bring the claim within 6 months or send a notice in within 6 months, then you can ask the court to condone your lateness. And one of the provisos is provided that the claim did not prescribe. So provided that 3 years didn't pass. So you must also tell the court that the matter is not prescribed in terms of the Prescription Act, so 3 years didn't pass. And this is my reason why I couldn't send the notice within 6 months. Are you with me, sir? I don't want to confuse you. Prescription in that instance is that you must send the notice within 6 months of the cause of action arising, right? That is, then you must send the notice. If you did not send the notice, the Act makes provision, because you send a notice in terms of that Act 40 of 2002. The Act make provision that you can ask for your lateness with that notice to be condoned, right? One of the aspects that the court that will be in your favor is that it is still within the 3 years, and also then you must have a good reasons as to why you couldn't send it timeously. But one of the aspects also is it shouldn't have prescribed in terms of the Prescription Act, which says that an ordinary debt prescribes within 3 years.
Okay.
Any more questions? Is another hand? Is another hand? No, one more. Whose hand is up? Okay, no one. Right, now, if you have raised a special plea, you can also plea on the merits. Now, pleading on the merits, sorry, not also, you can also, you should plea on the merits. That means now to each and every allegation in the plaintiff's particulars of claim or declaration, you must either do one of the following. You admit, or you deny, or you confess and avoid. You say, yes, it happened, like you say, but this is the justification for that. That is what confess and avoid means. Okay, so you do one of those three things. Now, those of you in practice, you would have all seen how people plead. They also say, the consent is noted. Did you notice that? Did you see that? So it's only those three. And then obviously, if you don't know, you don't know. I'll come to that later. So you either say, yes, I admit that what you say happened, or you say, no, I don't. I deny what you say happened, or confess and avoid. Now, if you don't admit or deny or confess to it and avoid it, then it is deemed to be admitted. So if you think you're going to leave out certain paragraphs because you don't want to talk to it, you don't want to address it, that means that you are admitting it. We can take it that you've skipped that paragraph, you are in agreement with it. Okay. Now remember, Rule 18 said that you must have it in paragraphs, one fact per paragraph, and you number your paragraphs, because in the plea, you are going to now respond to the specific allegations. You can do one of those things. Right. Now I have an example of an admission. Just give me 1 second. Say, for example, in the particulars of claim and paragraph 3 of the particulars of claim, this is just a random number that I've taken in the example, right? It says the following. The defendant was at all material times the registered owner of an immovable property described as Earth 123 Cape Town. And paragraph 4 is the defendant is in occupation of the property. Now, in your plea, and you will also number your paragraphs in the plea, and then the heading of that paragraph would then say what paragraphs you are now referring to. So it has at paragraph 3 and 4 thereof, or it can be at paragraph 3 if you're going to do paragraph 3 alone thereof, right? The defendant admits these paragraphs. That's all you say. Now, if a paragraph or an allegation is admitted, that means that the plaintiff must not prove that. He doesn't have to call a witness now and bring evidence to prove that, because they're not fighting about that. The defendant says, yes, that's right. What you're saying is true. Now, the at in at paragraph 3 and 4, you don't have to say at. People just sometimes say paragraph 3 or paragraph 4. And they don't say thereof, they just say paragraph 3 in the heading or 4 in the heading. It's a matter of style. At is Latin, it means two. So two paragraphs 3 and 4 thereof, this is what I'm saying. Now, I've specifically taken 3 and 4 together here because it runs consecutively after each other. And I'm going to admit both, so I'm going to take it together. In this specific particulars of claim, there's going to be other paragraphs that I'm also going to admit. But if it is not in sequence, then I can't take it together. For example, I can't say at paragraph 3, 4, 10, 20, and whatever, these paragraphs are admitted. No, I do it. I can only group it together if it is in sequence, and then I deal with it. And after that, I'll deal with paragraph 5. I'll make a paragraph 3, and then I'll say at paragraph 5 thereof, and then I will say what I say to that. Is that clear? I hope so. Right. If you're going to deny, that means you say no. And for example, the particulars of claim says on 12 August 2019, the defendant caused to be published defamatory matter of and concerning the plaintiff in an article in the Cape Argus, a daily newspaper circulating in the Western Cape. A copy of the article is annexed marked A. Right. The plea has at paragraph 3, you've numbered it, coincidentally, it's also paragraph 3. And here the defendant denies that he published the article and that it is defamatory of the plaintiff. Right. Now, the reason why I've taken such a paragraph with so many facts in, because I just wanted to show you how to deal with that. The many facts is the fact that there is a newspaper called the Cape Argus, and it's a daily newspaper, and it circulates in the Western Cape. Then you save yourself. You say, save as aforesaid, the defendant admits the rest of the allegations therein. So the defendant does not dispute that there is a daily newspaper called the Cape Argus in the Western Cape. So the plaintiff don't have to come and prove that. So we say, I admit that, but the other stuff I deny. And then you say why he denies it. Remember, if you're going to deny, you must substantiate why you deny. Okay, they talk about a bare denial. It mustn't be a bare denial. Substantiate. Say why do you deny it? Confess and avoid. For example, the particulars of claim says in paragraph 4, on 3 March 2018, the defendant unlawfully arrested the plaintiff in Cape Town. Then the plea reads like this. Paragraph 3 of the plea, and you're going to speak to paragraph 4. So you say at paragraph 4, and again, you don't have to say at, you can just say paragraph 4. At means to. The defendant admits that on 3 March 2018 and at Cape Town, he arrested the plaintiff. That is the confession. And here comes the avoidance, confess and avoid. But denies that the arrest was unlawful by virtue of the following facts and circumstances. And now, because there are more facts that is going to include, but it's under the same paragraph, you make sub-paragraphs. And that is how you do it. The defendant was a peace officer, as defined in Act 51 of 1977 at the time of the arrest. That is the Criminal Procedure Act, for those of you who don't know. On the date and at the time alleged, the plaintiff committed a crime in his presence, namely theft of a motor vehicle. Paragraph 3.3, the defendant was therefore entitled to arrest the plaintiff without a warrant in terms of section 41B and 41E of Act 51 of 1977. The arrest was therefore lawful. That is confess and avoid. Okay. Now, if you are not able to do any of the above, you cannot admit, deny, confess, and avoid, you plead non-admission. You just don't leave it out, because if you leave it out, it is deemed to be an admission. So you would say, and I don't have it typed out, but you would say, the defendant has no knowledge of the content of this paragraph, therefore he cannot admit or deny it, and he puts the plaintiff to the proof thereof. Okay, you've all seen that. So the defendant have no knowledge, therefore he cannot admit or deny, and the plaintiff must prove it. That is a non-admission. Even if you raise a special plea, even if you've in your plea raised a special plea of prescription, that does not mean that you now think you're going to win and that's going to be an end of the matter. You don't have to plead on the merits. You're going to win. Remember, you're going to court and you're going to argue. The plaintiff may just have some evidence to prove that the matter did not prescribe. And then there you sit. You are deemed to have admitted everything because you didn't deal with it. So even if you raise a special plea, you will always plead over on the merits. Right. Just something at this again, some thing that they will not ask you to know, but I'm going to tell you anyway because that is just my nature. If you're going to raise a non-admission and you're going to say that you don't know about it, right? And later on, during your preparation for the trial, you consult with witnesses, you get more evidence. And here you know about that fact that you say, I don't know anything about it, therefore I cannot admit and or deny it. And you know, it comes to light that you now know something about it. Remember at the trial, the plaintiff from the pleadings, that is the facts, of the opinion, rightfully so, that you don't know anything about this. So the plaintiff will prove it, but the plaintiff doesn't know if you now deny it, that you now have a witness who can deny it and what the witness is coming to say, what are the facts. So you can't just come and put a plaintiff into the box and now deny that allegations if you didn't alert the plaintiff to it. So you, as soon as you know, you must amend your plea and state now, okay, now I know what went on. This is I deny it for this and this reason. And then you're going to bring that witness to come and say that at the trial. Just remember that. So if you do a non-admission where you don't know about it, if things later come to light, amend your plea so that it correlates with the evidence that you're going to lead at the trial. Don't have in your trial no knowledge and then suddenly you have all the knowledge at the trial and the plaintiff is taken by surprise. The plaintiff can ask for a postponement and say, this wasn't pleaded, this is not facts that I know, I'm being prejudiced in the way that I'm conducting my trial, I need a postponement, and then the defendant should pay that for that costs. Okay, that's my piece of useless information, or useful to some. Right, this is just what must be in the brief. Again, I'm not going to go there. You can read that, what must be in the brief if you're going to brief an advocate to do the matter for you in the High Court. Right. Are there any questions on pleas in general? Because I'm now going to move on to something else. Yes, you may ask. I see a hand.
Good evening, Advocate. Can you hear me?
Yes, I can.
Oh, okay. When it comes to what you just mentioned, does it fall under the rule under discovery?
What now, ma'am?
What you just mentioned about
The non-admission.
raising a non-admission.
No, you must amend your plea. We're going to deal with amending a plea.
Okay.
If you want to change, then you can do an amended plea. We're going to deal with it. It's dealt with in terms of Rule 28. In the High Court, you would have done it when Rule 55 in the Match Court.
So yes. If the defendant's representative does not state that they are raising a non-plea and then the plaintiff didn't know about it, what does the plaintiff then bring when it comes to that? Like if they want to challenge the fact that they didn't know of such evidence.
Okay, they didn't know that you denying it, and they didn't know that you have a witness of it because you're saying that you didn't. What the plaintiff will get up, the plaintiff will alert, the plaintiff will address the court, the plaintiff will refer the court to the plea. The plaintiff will say, may I refer the court to the plea paragraph so-and-so. This is what we allege, and this is what the defendant said to that. They have no knowledge, and they couldn't admit or deny it. The fact, and then you would then broaden on it. The fact that there's now a witness who's going to deny it is news to us. It is prejudicing us. That is, if it's now really prejudicing you, it's prejudicing us in the way we conduct our trial, and we need time to prepare properly, and therefore the matter should be postponed. That is, if the plaintiff can, in the High Court, afford a postponement. A lot of times they can't, but I'm just telling you how it should work. A lot of times they can't because of the time that they will have to wait for a new court date, another year or another 2 years, and then maybe the risk is too much. But yes, you can raise it and you can say, this is the facts, doesn't correspond. The evidence doesn't correspond with the facts because the pleadings contain the facts and the evidence is laid at the trial about that facts that are in issue. And also, there would have been many times for the defendant to have remedied that because the parties have pre-trial conferences where they would look at the facts and they could have, but a lot of times I've seen people don't bother to amend and then they just rock up at the trial with all this evidence. And sometimes you are taken aback because you didn't know they're going to whatever they say they're going to say. And it
Oh,
is
okay.
unfair.
All right. Thank you, Advocate.
No problem. Any other questions? Okay. So I'm moving on. I've got a heading, defective pleadings. It's not headed like that in your notes. Right? Oh, sorry. I wanted to say something more, but what is it? Yeah. Did I say to you about the noted? The contents of this are noted. You would have seen that in please. When somebody says the contents of this paragraph are noted, it actually means I admit it. And why people would do that is because when the plaintiff's allegation refers to a copy, say for example it was based on contract, and then you say attached here to is a copy of the contract marked Annexure A, or the copy of the agreement marked Annexure A, then the defendant would say the contents hereof are noted because he sees it there. It doesn't mean, but it is deemed to be an admission. He admits that there's a copy of the contract attached to it. But for some or other reason, people say noted. And for many other things, people also say noted. But that, in terms of Rule 22 that deals with pleas, Rule 22 of the Uniform Rules, there's no plea of the copy of the contents of this are noted. Okay, it is deemed to be an admission, because the rule says if you leave anything out, it is deemed to be admitted. So if you didn't admit, deny, confess, and avoid, then you have admitted. Unless you say, I cannot admit or deny, then we know, okay, he doesn't know about it, he cannot do any of those. Right. Defective pleadings. I've said that because we are going to look for defects in the pleadings that we receive, right? The main pleadings that has to be scrutinized to ensure that they are not defective are the plaintiff's particulars of claim or the declaration and the defendant's plea. So when you receive a particulars of claim or a declaration or a plea from the other side, depending for whom you are acting, you must read it carefully to ensure that it is not defective. Right? Now, when would pleadings be defective? Right. If a pleading is vague and embarrassing, that is defective, then you would send a notice asking the other side to remove the cause of embarrassment before you take exception or note an exception. They use the two interchangeably. If a pleading lacks an averment that is necessary to sustain a cause of action or to sustain a defense, then you would accept directly. You don't send a notice to your opponent and say, remove this or fix this. Okay. So if a pleading is vague and embarrassing, send a notice, say this is vague and embarrassing. I don't know how to plead to this. Fix it. You have so much time to fix it. And if you don't, I will go back to court to have it struck. Okay, so an example of a pleading that is vague and embarrassing. For example, in a negligence claim, in a claim for, a delictual claim, the plaintiff makes the allegation that the defendant was negligent. He caused me harm and whatever because he was negligent. That's it. Now the defendant must plead to that. The defendant doesn't have a clue as what he did that was negligent. He doesn't know what was he doing. It's vague and embarrassing. The plaintiff, when you say somebody was negligent, you can say because he drove on the wrong side of the road. He didn't heed to the traffic signs. He was speeding. He had no regard for other road users. Those are the instances that tells the defendant how negligent he was. Okay, so that is how you would cure that. And that, just saying negligent without telling the defendant exactly how negligent he was, what he did that was negligent, is vague, firstly. And if he should now plead to it, and he must now think to himself, okay, I probably did this and that. He can't do the wrong thing. It would be embarrassing. Vague and embarrassing, right? A pleading that lacks an averment that is necessary to sustain a cause of action. Again, I'm going to use the DDIC because we've done that. There must be 5 elements present: the conduct, negligence, wrongfulness, damages, and the causation, right? If one of those is lacking, then there's no cause of action. Then you can accept immediately. The same with the defense. If the defendant raises a defense and it lacks one of the averments to sustain that defense, then there is no defense. Then you can accept to that. Right. So exceptions, by the way, is Rule 23. Now, when would you accept? When would you raise an exception? And they refer to the person who raised this exception as the excipient, because it can be either the plaintiff or the defendant who raises an exception. Now, when would you do that? If the excipient alleges that a pleading against which he accepts is inherently defective, he has the days which is allowed for the filing of any subsequent pleading. So if it is raised in relation to a defective particulars of claim or declaration, he has 20 days, because remember, the subsequent pleading after the particulars of claim or declaration is the plea that must be filed within 20 days. So you have 20 days, an exception in relation to a particulars of claim or declaration. Just to refresh your memory again on a declaration, that is what is used when a simple summons was issued and the defendant says, I'm going to defend. Now the plaintiff must file a declaration, which is exactly the same as a particulars of claim. Right? If it is raised, this is now an exception, if it is raised in relation to a plea, then 15 days, because 15 days after the defendant files a plea, the plaintiff can file a replication. So 15 days, yes, that is the amount of days. Right, this example of a plea, of a notice of an exception is in your manual. It is on page, I'm sure some of you who are following there, it's on page 113 of your manual, 113. Just have regard to that. An exception is heard as an opposed motion, as an opposed motion, and the court may uphold it or it may dismiss it, right? If it upholds it, that means that you are successful with the exception, or if you dismiss it, that means that's that. Now, can you appeal if an exception has been raised and dismissed? No, because then the main action is still alive. One of the parties raised an exception. He was unsuccessful. The main action is still in court, so you can't appeal that. There's no, that was just a interim application. It is upheld. If you are successful and it brings an end to that proceedings, then yes, because you can appeal final judgments and orders. Okay. The test that the court applies when he hears an exception is that the pleading that is being accepted must be acceptable on every reasonable ground. The pleader, that is now the person, the party whose document, whose pleading it is entitled to a charitable interpretation. Minor blemishes can be cured by further participation, and the pleadings must be read as a whole. So if you're going to raise an exception, just remember, from each and every reasonable ground, you mustn't be able to understand what is meant. If you read further and you read the pleading in context and it is clear, then you won't be successful with the exception. Okay, and if it is a minor blemish that can be cured by further participation, by making an amendment or something, then the court will allow that and not uphold the exception. Right. Now, what happens if you get a particulars of claim, right? And you see in the particulars of claim, let's use delict again. It's based on delict. See in this particulars of claim that one of the elements of a delict is not there, right? And you think to yourself, as their legal representative, you think to yourself, okay, I'm going to win this matter. Let's run it. I'm going to win this matter. We're going to be successful. You tell your client, we're going to win this matter because they don't have that. And you go right through the whole process of pleadings, preparation for trial, and come to the trial. And at the trial, you were right. You win the matter. But the court won't be happy with you. Because if you fail to take an exception when you should have, the court will not be happy with you. It is the duty of the litigant to take the most expeditious course to bring the litigation to finality. He should take such exceptions as will dispose of the dispute or bring the proceedings instituted to an end or to a conclusion. The court will in each case apply discretion and ask whether the party who did not take exception was unreasonable in failing to do so. And if the court is of the opinion that you are unreasonable by withholding to take an exception when you should have right at the start, you will be successful, but you won't be entitled to your costs. You remember the normal rule, the successful litigant is entitled to the cost. You won't get your cost because you should have accepted at the beginning and not wasted all this money by going right until the end. You're still successful, but you don't get your costs. Are there any questions on exceptions? You did this with Mr. Who's the guy? Mr. Pitt, or Advocate Pitt, as we call him. Do you have any questions for me? Or do you understand? You already knew this. Right. Again, under defective pleadings, I told you once about the irregular step when we did Rule 18, and I said that Rule 18, 12 says that if you do not follow Rule 18, remember I said Rule 18 is a checklist for what must be in a pleading, and then I had Rule 18.6, 9 and 10, and I had other things also there that I said you must check if everything is in there. Now, if you don't comply, that is an irregular step. So that is an example of what an irregular step is. Rule 60 of the Uniform Rules deals with irregular step. In match court, it is Rule 30. It's exactly the same content. Once you've seen that an irregular step has been taken, you take no further step. Because if you take the next step, then you can't raise this fact that there was an irregular step. So you take no further step. You send a notice to the other side to remove the cause of the irregularity. And if he doesn't, then you bring an application to court to set this pleading aside as an irregular step. Okay, obviously there are time limits in there. The rule says it, and it will come up. I've got a few examples of irregular steps so that you know what I'm talking about. An irregular step is where a summons was not served in accordance with the rules, right? Rule 4 says the sheriff must go and serve the first summons. If that wasn't done, it can be deemed as an irregular step. Where an address for service of documents did not appear from the summons. The rule clearly says you must have an address within 25 kilometers from the court. If it doesn't appear, then it's an irregular step. Where pleadings were not signed in accordance with the rules. Attorney signed. He forgot to say certified with right of appearance in the High Court. That is not signed in accordance with the rules. That is an irregular step. Where there has been a premature enrollment. You can only enroll the matter if the pleadings have closed. And if you think you want to jump the queue and enroll quick before that, then that's premature enrollment. It's irregular. Where an irregular notice of bar has been served, that's an irregular step. where review proceedings have been brought by way of an action procedure. Remember, review proceedings are one of those that where it is compulsory to bring an application. So if you've used the wrong procedure, then that's irregular. So you do nothing, you send them a notice and ask them to remove that cause of irregularity. And if they do not do it, then you go back to court, right? And this is the times. 10 days after you become aware of the irregular step, you send them a written notice to remove the cause of complaint within 10 days, provided that the applicant himself has not taken a further step in the proceedings. Where the cause of complaint is not removed within 10 days, the applicant applies to court within 5 days after the expiry of the 10 days to have the proceeding set aside. Any questions on irregular steps? No questions. I'm going to move on.
Actually, apologies, Councillor, if I might just ask one favor instead of a question. Could we just perhaps discuss the difference between the Rule 30A non-compliance and an irregular step, the Rule 32B? Is it? I think it's 32B, which is the irregular step, if I'm not mistaken.
32 deals with summary judgment.
Of
Okay,
course.
now,
Yes.
what are you talking about?
So just the difference between non-compliance with the rules and an irregular step. It's two different, I want to say, defenses one can use, but if you could just possibly explain the difference between non-compliance with the rules and an irregular step. And also just, I forgot what the notice is that you deliver in terms of an irregular step. Apologies.
An irregular step is dealt with in terms of Rule 60 of the Uniform Rules, right? 60, and I don't know what you mean by non-compliance with the rules.
For instance, your notice in terms of Rule 30A, where you would, for instance, file an answering affidavit.
Okay, you're talking about the Magistrates Court rules. Am I right? When you say 30A.
I'm not certain, because I think it is I think it is a notice in terms of Rule 30A where it's non-compliance or non-adherence with the rules, but it might be Magistrates Court. I honestly get so confused between the two at this point.
Let me just, 30 is irregular proceedings. Sorry, 30 is irregular proceedings. 30A is non-compliance with the rules. Okay,
Right.
it's the next slide. It says non-compliance. Okay, if you require someone to do something in terms of the rules for you in order for the case to move forward, for example, you send a notice to discover. Now, once a person receives a notice to discover, they must within 20 days after receiving that discover. Now, if they don't, so they don't comply with the rules, then you can bring an application to compel in terms of Rule 30A. So you apply to court for an order to compel. So it's 30 in the High Court and it's 30 and it's 60 in the Match Court. Sorry, you were right. I had it other way around. It's 30A, right? Non-compliance with the rules. So if a party fails to comply with the rules, then you or with a request made or a notice given, then you can actually go to court and compel them to do that. So you would just bring an application to compel. It will be a notice of motion, and it is to compel the other party to comply with the rules, and you will then in an affidavit just explain to the court what was done. On this day, you send that notice and what the time has lapsed and nothing has happened, and you want the court to compel them. And then when the court makes an order, the court will say, within so many days of this date of this order, the respondent in that application, it can be either of the parties, must comply with the court order. And if they don't, then you can then go back to court and have their case struck or set aside. That's the application to compel. I don't know what it is that you want about that. So you if a party fails to comply with within a period of 10 days, then the court can make an order thereon as it deems fit. Otherwise, his claim or his defense will be struck out. I don't know if I'm answering your question, because you made a comparison between Rule 30 and Rule 30A. What was the comparison?
Apologies, counsel. That I think that's where that's where I got confused. Now, just a comparison between what an irregular step is and what non-compliance with the rules is, just to see that difference.
Okay, I hear what you're saying. I've given you a few examples of what an irregular proceeding is. So is that non-compliance with the rules, or didn't they follow the rules? It is basically the same, but in this case, you wouldn't compel somebody to have the summons served in accordance with the rules. You would say, okay, this is what you didn't do, you should do it. Or the address doesn't appear, you didn't comply with the rules, but that is not. Rule 30A is more when the proceedings is ongoing and a person is required to do something in terms of the rules, and not only in terms of the rules. If the judicial case management, the court has given a direction that within so and so many days you will file this report or you will do that, and that isn't done, then you can compel them. Or even the filing of heads of argument. If there's a date set for that by court and the one party doesn't do it and is upholding the whole proceedings, then you can go to court to compel them to comply with that directive. Yeah.
Thank you, counsel.
But it's got to do with non-compliance with the rules. I can't really tell you. Yeah. An irregular notice of bar, that is not a non-compliance with the rules. Actually speaking, it is, but it's not in the sense that he was required to do something in terms of the rules and now he didn't do it. Review proceedings, that is the wrong proceedings. And address, yeah. I've never really thought about that in the way you asked it now. I'll think about it some more, but that's all I can say on that. But yeah, application to compel is Rule 30A. It is 60 and 60A in the match courts.
Thank you, counsel.
Okay.
Appreciate it.
Okay. Any other questions? Okay, yes, is a hand. You may ask.
Good evening, Advocate.
Good evening.
My question is, what happens in a case when let's take the defendant loses their locus standi during the proceedings? Can you raise this as an exception? Because I can see that it doesn't fall under special pleas. For example,
you can raise it. Well, look, that is not a conclusive list that I've given you. Those are just examples. You could raise non-locus standi also as a special plea.
Okay.
Raise an exception for locus standi. Tell me, what is the circumstances under which somebody would lose their locus standi during the proceedings?
Could be that the defendant can become a prodigal during the proceedings, or especially where on a plea of reconversion, or all of a sudden they become insane.
Oh, okay.
I
hear what you're saying.
Yeah.
Then you would just substitute the plaintiff for whoever is now dealing on his behalf, and that happens. You can substitute, say for example, the court orders that a minor parent
Yes.
or guardian should no longer appear in his behalf and they appoint a curator, then the curator, then that's just substituted. You just
Okay.
substitute the parties, you serve a notice of substitution, and then from thenceforth, it will be in that name. So if the person becomes insane, the curator ad litem will then step in the proceedings on his behalf.
Okay, so the court will give you like a period in order for that person to be appointed a curator.
Yeah, obviously you will then probably bring the application for the appointment. It's an ex parte application, so it goes quick. There's no respondent in yeah, and then you would just substitute the party name.
All right. No, thank you,
Okay.
Advocate.
That's pleasure. Any other questions? Right. We are still on Rule 23. I'm going back now to Rule 23. I'm jumping around here, but I'm just going to deal with the application to strike out. Remember, Rule 23 deals with exceptions and applications to strike out, for those of you who looked at the rule. So an application to strike out is if a pleading contains an averment or a statement which are scandalous, vexatious, or irrelevant. In the particulars of claim or in the plea, the parties are making all sorts of allegations that has got nothing to do with the case before the court, and your client will be prejudiced in the conduct of his claim or defense if the statements are not struck out. You then bring an application to court to strike out that part of the pleading that is scandalous, vexatious, or irrelevant. Okay, so if there's insulting things that is being said about the party, doesn't belong there. You know how some parties can get, especially in litigation, they give instructions to attorneys, put that in, I want to put that in, or whatever. Just remember, the party who's being prejudiced by that can bring an application to strike out. And there's always remedies for these things. And the court may cost orders or it follows the cause. If you bring an application to strike out against the pleading, the party who pleaded that or who put it in the particulars of claim must pay the costs. So it's unnecessary to put nonsense and irrelevant stuff in when you draft. I know sometimes it's difficult to resist your client when your client is paying you and telling you, but I want it in. And if you tell them, look, they can bring an application to strike out. Sometimes they still insist, no, but I want it in there. I want people to know this is the case. Okay, and that is in terms of Rule 23.2. Rule 23.1 is exceptions. Remember, we did exceptions, vague and embarrassing, or lacks an averment that is necessary to sustain a cause of action or defense. Right? With the one you first send a notice if it's vague and embarrassing. And in this case, it's with a vague and embarrassing, they must then remove the cause. Otherwise, you go back to court and ask to struck out. If it's one of the averments that is necessary to sustain a cause of action, you can take exception immediately. Here you bring an application to strike out if it is scandalous, vexatious, or irrelevant. Okay, this is just an explanation of the difference between an exception and an application to strike out. An exception implies that the pleading objected to, taken as it stands, is legally invalid for its purpose. An application for striking out of the offending allegations within the meaning of that term applies to allegations that, if removed from the pleading, will not affect its legal efficacy. So you just want certain parts of the pleading to be struck out. The pleading is still the same. You're not attacking the merits of the pleading. It's just certain things that doesn't belong there that you don't want there. You go to court to strike it out. Right. Here comes the amendment that I talked about earlier on. Now, Rule 28 deals with amendments. If you need to amend pleading, and these are all the documents that can be amended. A simple summons, a declaration, a combined summons, a plea, claim in the reconvention, request for further particulars of a trial, replication, rejoinder, documents, annexed to the pleadings and notices. Right. Now, how would you do this? Rule 28 says, and I don't have it here, Rule 28 says you send a notice of intention to amend to your opponent. So any party can do it, depending on what it is that needs to be amended. You send a notice of your intention to amend, and then you would say, so it will have the heading and it will have notice of intention to amend. And then it will say, be pleased to take notice that the defendant intends to amend its its plea in the following terms. And then you will say whatever paragraph, say paragraph 10, we will replace the words, and then you say what words will be replaced, and you say with what words it will be replaced. Or you will delete paragraph 9 and you will replace it with the following paragraph. That is how you would do. That is just the notice, right? And then at the bottom of the notice, you will say you have 10 days in which to object to this amendment. And failure to object would, if you do not object, it is deemed that you are in agreement. So they have then 10 days in which to consider that amendment. And if your opponent object to the proposed amendment, then the court must then hear your application to amend. If they don't object, then you just do your amended plea. You would just then include the amendments, and then in the tramlines, just to differentiate it from the original one, you would say amended particulars of claim or amended plea, and it will be exactly the same, but just with the necessary amendments affected into it. Okay. If they do object, then you can't now just affect the amendments. The court must then give you permission to amend. So if they object, you go to court, you set it down in court, and then you have to argue for your amendment. Now, what does the court do to decide to grant the amendment? If the pleading is going to, if the amendment is going to prejudice your opponent, and that is what they will have to argue and convince the court, that if the amendment is allowed, they are going to be prejudiced. If the court agrees with them, then the court won't allow the amendment. If the court do not agree with them, then the court will say you can go ahead with the amendment. And how can they then prove prejudice if you are now on the other side and you want to tell the court should not allow the amendment because you will be prejudiced? You must show the court that if this is now the new facts, I won't be able to have enough time to consult and to look at other evidence, and I am prejudiced thereby. If the prejudice that is going to be suffered can be remedied by a cost order, the court would rather give the cost order and allow for the amendment. Now, if there is enough time left, if it's months before, and the court would usually allow the amendment if the one party is objecting. But if it is close to trial or just the day before trial and somebody comes with an amendment and it's going to prejudice you, then you must convince the court how it's going to prejudice. If the court is of the opinion that you're not being prejudiced, then the court won't listen to you and rather grant the amendment. Okay. Just know that you can amend anytime until before the court hands down a judgment. So during trial, you can also amend. Sometimes during your case, when you call your witnesses, they may say something totally different that they didn't say. Maybe they just realized it or they didn't tell you. Then you can ask the court if you can amend your pleadings in accordance with what the new evidence is. Okay. What in claims for damages, a lot of times people change the amounts that they claim if it is less than amounts that they have evidence for at the time of the trial. They may have estimated, because remember, when you have consulted, it was 2 years ago. And also you didn't know the real extent of the damages because you didn't have experts look at whatever the damages was. But now it's 2 years later, or you get experts to tell you, and the amount changes, and what you've estimated is maybe too low. So then you must increase that. Then you amend to change the amount. And you would just say amend that to change the amount to whatever the new amount is. And if your opponent want to object, you have to argue in court, and you have to show the court why an amount that is changed is going to prejudice him. Because an amount can't prejudice you that if it is changed. Say, for example, initially the claim was for 1 million, and just before the trial starts, or even during the trial, it is changed to 5 million. There's no real prejudice, because remember, your defense is not in the amount, it is in the facts. You say, I'm not negligent, I didn't cause that. So whatever amount they want to claim, your defense is still the same. So what more do you want to do? How are you prejudiced? What more could you have done to prove your defense? You don't need more defense just because the amount is more. I don't know if I make any sense to you. Do you have any questions? Okay, no questions. Right. I want to move on to a new topic, but I think we'll break and then come back at 15:15, if that is fine with everyone. We'll go for our comfort break.
Perfect.
Okay. Yeah. Okay then. See you at 15:15.
Ditebogo, Montle, please mute.
Okay, I'm back. Are there any questions? Okay, I'm going to now move on. I wanted to show you a amendment, but I'm sure you've seen amendments, notice to amend. Let me just, sorry. Let us move on to the next slide. Right, this is the third-party procedure. Now, I just need an indication from you. Did you do third-party procedure with Advocate Pitt? Because I want to know how much of this you know already. Did you do third-party procedure with Advocate Pitt? Anyone? Can I ask someone in specific? Can I know? Who knows?
Please proceed with it, advocates. It's fine. I think you did bring it up.
No,
but-
no, I don't want to know. I don't want you to tell me that I must proceed with it. I want to tell you to tell me whether Advocate Pitt dealt with it.
He did, but it's still rough in our minds. Well, in mine at least.
Okay, so you know what I'm talking about. I just want to know what I'm dealing with here. You know what I'm talking about. Right.
Yes, I do.
So Rule 13 that deals with third-party procedures in the High Court, it's Rule 13. It is used where a party in an action claims as against any other party who is not a party in the action, that such party is entitled in respect of any relief claim against him to a contribution or indemnification from such party, or where any question of law which has arise or will arise between the parties is the same, and then you can join somebody as a third party, right? You understand that? So, let me just take you back. The action claims that he is entitled in respect of any relief claimed against him, then he can use this third party procedure. Right. They say that, and I'm just looking at the rule. I just want to see if they say that in the rule. I don't say that, but I thought they were going to say. The purpose of this rule is to avoid a multiplicity of actions. What that means is that the purpose of it is to avoid you going to court many times on the same facts. Right, am I still on? I am. Okay, the rule is complementary to, but does not supersede the machinery laid down in Section 2 of the Apportionment of Damages Act. Now, I take it that you know what the Apportionment of Damages Act is, but I'm going to tell you about it, because it is important that I start there when I explain to you the third party procedure, right? So just the Apportionment of Damages Act. Think back to our first evening where I had those two motor vehicles, right? The two motor vehicles that collided. Let me just get back to that motor vehicles. Just give me a moment. It would be better for me to explain it to you. Right, you see those two motor vehicles. Now, the Apportionment of Damages Act worked like this. For the purpose of my explanation now, just assume that the driver of the red vehicle is also the owner of the red vehicle, and the driver of the green vehicle is the owner of the green vehicle, right? So they both have locus standi. Let's also assume that the driver of the red vehicle sues the driver of the green vehicle for the damages to the red vehicle, right? Remember, I'm explaining the Apportionment of Damages Act to you. I'm not yet with Rule 13, with the third party. I'm explaining something else. So red car is the plaintiff, green car is the defendant, right? Red car claims 1,000 rand from green car, from the defendant. The plaintiff is the red car, claims 1,000 damages sustained in the collision. And the plaintiff alleges in his particulars of claim that that green car was negligent because he drove on the wrong side of the road and he was speeding. Right? That is what the plaintiff alleges. They go to court. At the end of the day, red car proves that his damages is 1,000 rand. He proves that. But part of the defendant, the green car's defense, was that red car caused some of his own damages. He alleged in his plea that the driver of the red vehicle, that the plaintiff, could have swerved away to avoid the collision. But he did not. So part of the reason why his damages is that extent is his own fault. He did not do anything to mitigate the damages, to make it lesser. So the court then makes a decision that, okay, green car defendant, you are 70% liable for the damages to the plaintiff's vehicle. And the plaintiff, the red car's owner, is 30% liable for his own damages. And I'm not talking about the damage to the green car. We're just talking about the red car suing the green car. Right. So he proves damages of 1,000 rand then the court say, defendant, because you are 70% liable, you must pay the plaintiff 700 Rand. The 30% that the plaintiff is responsible, that is his own, must come out of his own pocket. So he must prove whatever amount of damages he proved, 70% the defendant must pay. That is the Apportionment of Damages Act. Right. So that is where I wanted to start with the explanation of third-party procedure. Now with the third-party procedure, let's look at the vehicles again. And you will see that I say the Rule 13 third-party procedure is complementary to, but it does not supersede, it does not replace the Apportionment of Damages Act. It's complementary to it, right? And it says where a party claims that he can be indemnified for whatever is being claimed from him. So there is this collision between these two vehicles, right? Again, we're not talking about the damages to the green car. The damages to the red car is what is going to be claimed. But there's a difference here. Imagine yourself that the driver of the red car is not the owner of the red car, right? The owner is someone else. So let's put the owner, let's call the owner A, let's call the driver of the red car B, and let's call the driver of the green car C. So the driver of the green car C is the defendant, right? The plaintiff, because remember, the driver of the red car does not have locus standi because he did not suffer any damages to his property. I'm not talking about personal injuries to the property because the car is not his property. So A is the plaintiff. Is not on the picture, but A is the plaintiff. A and B, who is the driver, they are related. They are sisters or brothers or best friends. Let's say they're sisters. See, that's a woman. Let's say they're sisters. So A sues C, sues the defendant. Right? The defendant receives the summons. The defendant then says, but let's look at Rule 13 again, where a party in any action claims as against any other person who is not a party to the action. So A, who's not on this picture, is the plaintiff. C, who is the driver of the green car, is a defendant. A and C are the parties. One of these parties wants to claim from a party who is not a party to the proceedings, because the parties are the plaintiff and the defendant. B is not a party. B is the C says, B, you can indemnify me or contribute for the claim that is against me. So C will then serve a third-party notice on B, who's the driver, and say, you can indemnify me or contribute to the damages. So that notice is then served on to B. The notice must state the nature and the grounds of the claim of the party issuing the notice, and what is going to be decided in court. All the pleadings are then served on to B. B then participates in the proceeding as if he is also a defendant, but he's not a party, he's the third party. He participates because, remember, the whole purpose of this procedure is to avoid a multiplicity of actions, and you're going to see now why. So he participates. The court then decides, makes a decision. The damage who's not on the pictures vehicle, the owner, the plaintiff, is 1,000 Rand. The court also decides that C, who's the defendant, is 70% responsible for that damages, and B is 30% responsible. He was the driver. He could have avoided the collision. The court Then in third party procedure, this is what the court does. The court does not make a monetary order against the third party. The court then says, A has proven his damages as being 1,000 rand. The defendant must pay the 1,000 rand damages because the court is not going to make a monetary order against the third party. So a defendant C must pay the 1,000 rand to the plaintiff A. The court made a declaratory order in terms of the percentage of damage that is responsible, being 30%. C can then use that declaratory order to claim that difference of what he has paid to A from B if he wants to. And that is what third party procedure is. So that when they do, if C takes B to court, they don't have to have the whole trial again. The court has already declared what is the damages and what is the percentage that the third party is responsible. But the third party was not a party to that proceedings where A was the plaintiff and C was the defendant. Are you still with me?
Yes, we are.
Do you have any questions at this stage? Is it very clear to you? You understand it, but you did understand it before. I'm just refreshing your memory or doing revision.
Can I ask a question? Sorry, I forget.
You can always ask a question.
Yeah. So the facts of the first case, yes. So the facts of the first case that was decided between A and C will then be brought into the case between B and C.
It's not brought into, there's already an order that says what B is responsible for. But remember, B and A in relation to each other are not parties. A did not sue B. A was never going to sue B as they're not going to be in court as opponents.
Yeah.
So, but now C already has the declaratory order. There's already an order, but the order is not in monetary terms. It doesn't say that C must pay that B must pay anyone. No judgment sounding in money may be sought against the third party. All that can be sought is an apportionment of fault in the form of a declaratory order.
Okay. I get it.
Okay, so they don't have to then prove the whole case again if they do go to court.
Okay.
Okay. Any questions? No questions.
Just more clarity. So it cannot be monetary. It's just a declaratory order against B and C.
The court is not telling B that you must now pay 30%. Remember, in the apportionment of damages, the two parties both is responsible for whatever damages. And in that case, the one will only pay to the extent of his damage to the other one. That is the Apportionment of Damages Act. So this one is different. This is the third party procedure. That is why I explained the other one first, so that you can, when I come to this.
So there's no way that C could get
I'm listening.
Yes. So my point is, in this second case, so to speak, between B and C, there's no way that C can now force the hand, make a case so that B can assist him to pay A. So it cannot be monetary, whatever it's decided.
The court did not make that order. Yeah, the court did not order B to pay A anything.
because B was never part of the case because it was always between
Yeah.
A and C.
Yeah. But C said, you can indemnify me or contribute to this claim that is against me.
Okay, that's the first
Advocate?
case.
Yes.
Hi, Advocate, you're speaking to Leslie. Okay, you are saying
Yes,
in
Leslie.
the third party case, C cannot, the court didn't order that B pays A. But in the third party order, can you mentioned indemnify or contribute? So C in the third party case may ask B to help him pay. No.
He can ask B, but B is not obliged because there's no court order that say B must pay anything. It's just
Pardon,
a declaratory
Advocate?
court order.
You
But he
broke
can
up?
go after, he can then sue B afterwards for that money that he had to pay.
So C can sue B afterwards for the money he had to pay
Yeah,
A.
and then they don't have to have the whole trial over again because the court has already declared what is the amount. So
All right.
either you can say, look, I'm going to court, you can pay this that the court has set your responsibility, or the court can pay me. Because remember, in relation to B, C is not the defendant in relation to B being a plaintiff. They're not. B is the third party. A is the plaintiff. C is the defendant. The case is between A and C. C serves a third party notice on B saying, look, I'm not alone responsible to A's damages. You also contributed. But in this case, the court don't make a monetary order against.
All right, Advocate, now.
A declaratory order, which.
Pardon, how is B then able to contribute to C if it's not monetary?
What do you mean contribute
you
to
mentioned
he can go later with that declaratory order, but the court is not going to in that proceedings make the order in monetary terms against. He's not going to order B, you must pay so and so. Not going to make that order. He's just going to make a declaratory order declaring that you are responsible for 30% of the damages.
B.
Yeah. And then C can use that declaratory order to get the money from B.
All right, so B can't just deny and refuse to pay. When C takes B to court, in terms of a third party action, then B, there can be an order made that B help pay C for what he had to pay A.
There's already a declaratory order, so all that the court must do is the court must now say B must pay that money to C. So then B will be the plaintiff in that second proceedings, and B will be the defendant, and C will be the plaintiff.
Yes, thank you very much. Is that separate proceedings, Advocate, pardon?
Yes, that will be a separate one.
All right, thank you very much.
Because remember, A instituted this proceedings, and A had no desire to make the proceedings and to join
B
as a co-defendant. A had no desire to do that.
Yes, all right, thank you very much, Advocate.
Okay, is that Leslie, no? Yes.
Yes, Advocate.
Was there another hand up? Okay. So is that the same like you understood it in match court? Can I just get it someone? Is that how it was explained to you in match court? Right, thank you. I saw a thumbs up, I think. Let's move on to the close of pleadings. We now come to the close of pleadings, called also litis contestatio. That is in terms of Rule 29. And this is exactly what is in Rule 29. This is when these four instances, then we are at the close of pleadings. it is if any party of the other parties joined issue without alleging any new matter and without adding any further pleading. If the last day allowed for the filing of a replication or a subsequent pleading has elapsed and it has not been filed. Remember, after the replication, you get the rejoinder, surrejoinder, rebutter, surrebutter. That. If the parties agree in writing that the pleadings have closed, and if the parties are unable to agree as to the close of pleadings and the court, upon the application of a party, declare them closed, then the pleadings are closed. Right. If you are paying attention, you would think to yourself, but if time lapses and the pleadings are closed, why would the court have to get involved into telling parties that the pleadings have closed? Why would it be necessary that last instance, if the parties are unable to agree as to the close of pleadings and the court, upon the application of a party, declare them closed? Remember, an application case of motion affidavit, you have to wait for a court date. More time is going to lapse and the pleadings are going to be closed. So why do you think the court must get involved in declaring pleadings to be closed? It is only in the instance where a claim is for personal injuries, pain and suffering. The effect of the close of pleadings is the following. The plaintiff's rights are freezed as at that moment. So the plaintiff's rights are freezed as at the moment of the close of pleadings. A claim for pain and suffering is not transmissible on the death of the injured. So then you would be able to claim that money to the party, the plaintiff dies before the close of pleadings. So you would understand that it would be very important for the plaintiff's people to say that the pleadings closed before the plaintiff died, so that whatever claim for pain and suffering can be transmitted to the estate. Remember, the executor will now stand instead of the plaintiff. The names will just be changed. For the defendant, it would then be advantageous if the pleadings has not open when the plaintiff died, because then it will just get rid of that claim for pain and suffering. So in that case, people run to court because now they can't agree at what specific point in time the pleadings were closed. And was the plaintiff still alive at that time, or did he die at that time already? That is the instance where people would go to court to have the court declare that pleadings have closed. Okay, any questions? Okay, I just want to again give you a tidbit of me going extra. There's this case, it was in Gauteng. Just want to get the full. I just want to get the full case. I don't know if some of you know about that case. You would all know it if I'm going to tell you. If I'm going to tell you about it. It was a case that was in the High Court of Gauteng in Johannesburg, right? Do you remember those miners who all got silicosis way back, right? It is the case of Nkala versus Harmony Gold Mining Company Limited. These miners, some of them died of silicosis because of the asbestos in the mines. I'm sure you know about that, if you've read something. They went to court in a class action against Harmony Gold Mines, right? And at some stage, there was a special motion court that were dealing with some aspects of the case before it goes was supposed to go to trial. And I say supposed to because it did not go to trial. In that case, the court made the following interesting decision. It said that heirs of people who have deceased already, and even though they did not even institute proceedings and are not part of the class action, but their people also died, they can still claim now, which goes totally against this principle that a claim for pain and suffering is not transmissible on the death of the injured. It's totally against that, because here, even if you did not claim yet, you can now still claim. This matter, after that, it's settled out of court, so we didn't test it, but I mean, the court made in that special motion, made that decision, but that is only in Gauteng. And if you know the principle of stare decisis or stare decisis, as some of you might say it, what is the English for stare? The principle of precedent, that the lower courts are bound by the high court in a specific division, and in the high court, so Gauteng, but other divisions are not bound by that. But there they made that, in that decision, they made that pronouncement that even though we're not even talking about close of pleadings, there isn't even pleadings, they said heirs can still come and they can still claim. So yeah, like I say, that matter was settled out of court eventually, the claiming part, it was a class action. But we have, if you should ever come across, and the reason why I'm telling you this information is that whenever you in practice comes across a case like that where the pleadings have closed, look up that case in Kala versus Harmony Gold Mines and read it. It's a very long judgment, but it's interesting, and it will give you some guidance as to how to persuade the court in whatever division you are that this is what they should apply, and that your claim can still be transmitted. Okay, that's the reason why I'm giving you that bit of information. Use it, don't use it, it's fine. Right, so when the pleadings have closed, we now come to the procedure of preparation for trial, the practical arrangements for the trial. We now finished with the first part, we're now in the practical arrangements for the trial. Right, and I've got a few notices of here, discovery and after, notice to discover, notice to inspect, and all of that. This is dealt with in terms of Rule 35 in the High Court. Rule 23 is the match court. It's exactly the same, the content of it. So discovery, and we've talked about discovery at some stage. If you get a notice to discover, now in terms of Rule 35, your opponent will send you a notice to discover, and then you are obliged to discover, right? And if you do not do, then that question of, is it Janus? I think it's Janus, where you can compel somebody in terms of Rule 30, capital A. But before we get to Rule 35, I first want to tell you about this, Rule 37. This one. If nobody, during the whole preparation for trial, you were not called upon, because remember, they're not obliged to ask you to discover. They will ask you to discover if they want you to discover, and it can be either party, either the plaintiff or the defendant. If that didn't happen and no discovery happened, when you receive court date, the trial date from the registrar, you now know this is the trial date. 15 days after you have received the trial date, in terms of Rule 37(1), you are obliged to make discovery, even if no party has asked you to discover. So you're going to discover in any way, you are obliged to discover 15 days after receiving the notice of a trial date. And even if you have nothing to discover, you must still file a discovery affidavit. And in that affidavit, you must say, I have nothing to discover. Okay, so there is an automatic discovery that happens as soon as you receive the trial date. Otherwise, you will that is not if now no discovery happened. The rule of discovery is the following. If you did not, you may not use the document that should have been discovered because you did not disclose it. And your opponent may use a document that was not discovered by you. Now, what documents should you discover? You should discover all the documents that are relevant to the trial that you have in your possession, or even that you once had in your possession, but it's no longer there. If you didn't discover a document and you later want to use, you are not allowed to. You are barred from using it. Right. Now, Rule 35.1 says that you, when you receive a notice to discover, then you must, within 20 days after receiving that notice, file a discovery affidavit. And then it tells you, Rule 35, the discovery affidavit consists of the following two schedules, Schedule 1 and Schedule 2. Schedule 1, a list of documents and tape recordings that is in your possession. And it has two parts. It has part 1, which will be a list of those documents and tape recordings that your opponent may look at, may see. And then Schedule 2 would have a list of documents that your opponent is not entitled to see. It's privileged documents, but you still discover it. Privileged documents would be communications between you and your client, you as the attorney and client, right? And then Schedule 2 would have a list of documents that you once had, but you don't have it anymore. It was once in your possession, but you don't have it anymore. It's with someone else. You still discover, you put in the discovery, okay, I once had this, because you may want to use it. Okay, I'm just looking for I know there's a discovery affidavit, which I'm looking for. It is on page 250 of your guide. There's a discovery, an example of a discovery affidavit, what it looks like, right? So in terms of Rule 35.1, any party can ask the other party to discover, and then the party receiving that notice to discover is obliged to discover within 20 days after receiving that. Remember how we compute days? Foley, first day out, last day in, court days only. So then you must discover within 20 days. And you do it in the form of an affidavit. At this stage, no documents are exchanged. You don't give boxes and boxes of documents as we see on TV, how the Americans, when they ask for discovery and the other party come, then they come with all the documents. No, it's just a list, but it's in affidavit form of the doc. Have you had documents you can see and documents that you may not see, but I have these documents. It's privileged information, but you listed, say, letter from me to my client, dated so-and-so, letter, whatever. In fact, it's not from the attorney. The plaintiff will be the deponent of the affidavit. Now, if you receive the discovery affidavit and you now go through the discovery affidavit with your client, you as the attorney, and your client tells you, but everything that discovered, say, for example, it is a divorce and there must be a division of the estate. And your client tells you, but not all the property that is in the estate is on here. Something is missing. Then you can ask for better discovery. But when you ask for better discovery, and it is in terms of Rule 35.3, when you ask for better discovery, that is documents that is not disclosed in the affidavit, you can't go on a fishing expedition and just say not everything is discovered, give you more. You must specify the documents that you say is not discovered that should have been discovered. It is a policy or it is shares or whatever. You must specify the documents and it must be relevant to the trial, to the case. can't be irrelevant. So that is a better discovery. In terms of Rule 35.3, you send a notice for better discovery. Right. In terms of Rule 35, sub-rule 6, and there's a form to the uniform rules, form 13. You can also send your opponent a notice to inspect. This is now when you want copies of the documents, and it doesn't have to be everything that you can say, I want to inspect this and this and this on your affidavit. This allows you to get copies of that documents, right? Usually these days, they will scan it and email it to you. Okay, just a bit of history. In the past, you used to send a messenger to go and make copies of it, and you would pay for the copies. But we have modernized now, so they would usually scan in the documents and send it to you. Maybe they will send you hard copies also, I don't know. If a party is called to discover and it does not discover, then you can do a notice to compel, Rule 38, right? The court can then dismiss the claim or strike out the defense in terms of Rule 38, and a special cost order may follow. I mean, I talked to that already. I'm not going to talk to it again. You can also ask your opponent to specify. So you will send a notice to specify, that is in terms of Rule 35.8. This notice obliges the other side to list all the documents and tape recordings that they are going to use at the trial. Remember, everything that they have and or had that is relevant. Now, that is not that they're going to use necessarily, but it's all relevant. Now you want to ask them, what are you going to use of all these documents, so that you know how they are going to conduct the trial. In South African law, we do not have the surprises where people just come up and they tell you stuff that you were not aware of and all taken aback. You will know when you go to trial what documents they're going to use. It will help you to prepare better, and you also know how they are going to do their case. You can also send them a deuce. This notice entitled obliges the other side to bring a document to court. Is there a question? I see a hand.
Yes, Advocate, it's Cindy. I just want to know, I see that they need to provide a list, is this in civil matters, of all the documentary evidence they intend to use. But is this the same even in criminal matters? Because I was under the impression that they dump a lot of documents in discovery, and then they then decide which matters, which documents or evidence they'd like to use. It's for the opponents to just study everything. Do they have to in criminal matters?
Yeah, you're talking about a request for further particulars, and that is criminal procedure. In terms of the Criminal Procedure Act, I can't remember I've done the criminal law a lot in the past, but I'm not doing it anymore. I can't remember the specific of the criminal 70-something, section 70-something. I just know 77 or 75. Okay, this rules don't apply to criminal procedure. So when they give you further particulars, they will give you all the statements and stuff, and they can decide whether they're going to call all those witnesses or not. Yeah.
Okay.
It's different.
Okay.
So this rules only apply to civil practice in the High Court. It's the same in the Match Court, Rule 23. The contents are the same. Yes, there's another hand. Okay.
Yes, Advocate, good evening. I have a question with regards to the discovery. I'm trying to think of a scenario where it's a divorce matter, and if the parties, for one reason or the other, they've just separated for a long time, I can just say maybe 5 years, and therefore don't know what has been happening with the other spouse's life, what they've accumulated, what they've lost, and whatnot, and they're married in community of property. How does discovery then work in that instance? Because if we then apply for discovery, what are we discovering? Because we don't know. And I think at that point, wouldn't that be a fishing expedition where we just want them to tell us what the other spouse has? And then also what happens in the instance where they do file a discovery, they don't specify what they want to know. Are you obliged to volunteer what assets you have?
You are old.
Is somebody answering? Hello? Okay. When you send a notice to discover, right? If the parties are married in community of property, there is necessarily going to be a division of the joint estate. But if parties lived apart from 5 years, evidence can be laid that this was acquired after they've left, and courts can make decisions as to whether it should be regarded as part of the property. It's not a fishing expedition to ask for discovery. They must discover everything. They can later come and argue that this shouldn't form part or that shouldn't form part of the joint estate and should not be counted when they do the division. But they must discover each and every relevant document that they have or had in their possession.
The
that is
Nancy
relevant to the
Ellen,
trial.
please mute.
So that is what it is. Discovery of documents and tape recordings. So it is not discovery of I have a 4x4 if you don't have documents of the 4x4, or I have I don't know. I have new furniture.
Okay, and so in this
That is
instance,
assets. You're talking about assets. If you want a list of assets that they want,
yes, yes,
that
so
would
that
be
we
for
can
the division of the joint estate. So you want them to discover a list of assets.
Yes,
that they have acquired after they have separated.
It can be during or after. In, like, I could say both. Are you obliged to volunteer that I've got this and that if they don't claim for it?
If they don't know about it.
Yeah, if they don't know about it, do I have
Because you can ask for better discovery if certain of the... I don't understand your question really. Just to say that last part again, do you have a...
I want to understand if during discovery, does one spouse or is there an obligation on any of the spouses to sort of reveal what assets they have?
Yes.
For example, if one has a car that they've bought, the other one is not aware of it, and now they're dividing the estate, are they absolutely obligated to disclose it?
Yes, because they're married in community of property, and the stuff don't just belong to one or the other. They will have to prove in court that the other one is not entitled to that, but they must discover everything that they have because it falls within the joint estate.
Okay. All right. Thank you very much, Advocate.
If they leave something out and the other party is unawares and don't ask for better discovery, then they get away with it. But I mean, they have to discover everything. It says they are obliged, everything that is relevant. Now, in a divorce, where there's going to be the division of the estate, where the proprietary rights of the parties are going to be at issue, for the purpose of that, there has to be discovery of all the assets that the parties have, whether it's going to be given or divided or taken into consideration. That can be argued to the court, that this car was bought with my own money, separate. We weren't living together. We didn't share that. You could argue and the court might find in your favor, but you have to discover it. Yes.
Thank you very much.
Okay.
I understand.
Fine. Any other questions?
Hello, Advocate, can you hear me?
Yes, I can.
Yes, ma'am. So in other words, in divorce matters, we can safely say we can do a fishing expedition exercise to look for what we don't know.
Look, if you want better discovery, then you must ask specifically what you want. If so you must probably, if you think that somebody has some things that you don't know, a phishing experience, you can't do it through the discovery process, but you can do it by finding out. There's public records of stuff that you can find out. You can go to the deeds office, ID number, see how many property this person have, and then you can say you must specifically discover the documents of X, Y, and Z. There's ways to find out, I think, on ITC what cars is registered on a specific person's names. So you do that. You don't do that through discovery by finding out that. You know that, and then you ask for better discovery by specifying what still must be discovered. So there is a way around it, but it is not using the discovery process, because if you're going to ask for better discovery, you must specify what must be discovered. But there's ways to find out what people own if it is in their names.
Thank you, Advocate.
Okay. Right. You can also send your opponent a notice to produce. Now, this notice to produce obliges the other side to bring one documents or tape recordings to court. So this documents that you want them to bring to court is documents that they have discovered, documents that they have listed in their discovery affidavit. You want them to bring it to court. This would enable you to submit that document or tape recording to the court as evidence in your case. You do not have to prove that the document or tape recording is original and authentic. You may simply hand it into evidence. Okay. Now, what I mean, what it means, what I'm saying there is that you will be able to submit the document. You don't have to prove that the document is original. This is a document that they have discovered. Now, for those of you in practice, for those of you in practice, you would know that documents must be proved if you're going to use it in court. How do you prove a document? You would call the writer thereof. And then the writer will go in the witness box and he will say, did you draft this document? Is that your signature? Under what circumstances did you do it? Where did you get the information? What was the instructions? All of that you will have to place on record. That means proving a document. If it is a document that they have discovered and you send them a notice to produce, you don't have to do that. You don't have to prove that the document is an original document or that it's authentic. You may just simply hand it into evidence. So the document is then what it purports to be. Okay. Yeah, you don't have to prove that the document is original or authentic. Do I have any questions on that? Is that clear?
Me
Right,
again,
next
Advocate.
point. It's the same thing, but it's, yes.
Advocate, sorry,
Yes.
on the documents part, so do all documents that you hand up in terms of proving need the original author? So for other circumstances where you cannot get the original for whatever reason, can you get other people to corroborate the authenticity of a document without having the person that actually authored it?
No, you have to prove it unless your opponent admits to the document.
Okay.
That is the next notice, the notice to admit. That is when one of your documents you want to use at the trial, you send them a notice document, and then if that document is admitted, then you do not have to prove it as is original and authentic. You may simply hand it into evidence. If they don't want to admit it, then you have to prove to the court that the document is original and authentic. Okay, that
But
procedure saves costs. Yes.
Okay, but can it be handed up provisionally and then proven at a later stage?
Yes, yes, you will tell the court, I'm going to call the witness who's going to prove this document at the later stage. And the court will make a note provisionally accepted. Because then you can ask questions on the document. But remember, if you don't prove it later on, then that evidence, the weight attached to that evidence is lesser than what if it was if it's proved.
So I must just make sure that I remember to get it admitted before I close my case.
Admitted to what? You must prove the document. But usually
Yes,
the court don't allow you. Provisionally, I hear what you are saying. Maybe in some instances a court will do that. In my experience, the court, if you start asking questions on a document, your opponent will jump up and say, but what document is this? Document has not been proved and we did not admit this document. Now, when I say admit, I don't mean that you admit what is in the document. Admit, if you admit a document, it means that you admit that the document is what it purports to be. Say, for example, I say this is an invoice received from Woolworths. We all agree that that is an invoice received from Woolworths. We do not, the agreement is not that the content of that invoice is correct. That must still be proved. But the fact that the document is what it purports to be, that is admitted. And you don't have to call Woolworths managers to come and prove that the document is one of the documents from one of the machines. Okay.
Yeah. Yes. Okay. But I was just saying that a document where I don't have the original author, but I have ways in which to eventually get it finally admitted in argument, whatever the case would be, I can ask the court to provisionally hand it up just to fast forward the process, lead my evidence, and later on get somebody to corroborate the authenticity, even though the defense opposes whatever is contained in the document, right?
Yes, you're right. You can do that provision, and then you can say, I'm now going to call the witness who's going to, and it's up to the court whether they're going to accept or not. And obviously your opponent can also cross-examine this person to try and prove that they don't really prove this document. But you can, your way, it seems like you're speaking from a specific fact or something that happened to you or that you're busy with.
Yes, okay, thanks.
Okay, any questions on discovery? That was the end of discovery. Any questions on discovery? None. Okay, I'm moving on. Right now we're going to deal with Rule 36. This rule changed, this part that we are dealing with changed last year. It was amended in 2022. Right, where am I? Yeah. It is the Rule 36. It deals with inspections, examinations, and expert testimony.
Your 36A and B, when you're filing your expert testimony, your expert reports.
That has changed. Was it last year? Yes. It was amended last year.
Your 36A and B. Yes.
Yeah, okay. So if you are going to call an expert witness, then you have to give notice to your opponent that you are going to call the witness and who the witness is, discipline, or what category is he an expert. So if it is bodily injuries and the person's leg was broken and you're going to call an orthopedic surgeon who's going to come and testify in court that the leg was broken, then you must give a notice that you intend to call this expert witness, Dr. Smith. Right? That is the 36(9)(a) notice, right? This notice must be sent to your opponent. If you are for the plaintiff, it must be sent 60 days after the close of pleadings. Right? I'm going to tell you history again, how it was before that. But just to know, for now, it must be sent after the close of pleadings, right? 60 days. And if the defendant is going to use an expert of the same discipline to contradict that expert, then he must send a notice of the expert. But I don't want to talk nonsense to you. I think I have the notes here. Yeah. Oh, the defendant, the plaintiff is 30 days. I was talking nonsense. Not more than 30 days, and the defendant not more than 60 days after the close of pleadings. They must send, that is just the notice, who they're going to call. Then 90 days after the close of pleadings, the plaintiff must send a summary of what the expert is coming to say in court. What people do in practice is they would usually just send the expert's report as compiled by the expert, but you can have the expert's evidence also. Actually, the rule says you must send a summary. People don't summarize it, they just send the whole report because they are lazy. It's the only explanation. And the defendant, 120 days after the close of pleadings, he must send a summary of his expert report. So if you are going to use a couple of experts, you must remember, if you're for the plaintiff, 30 days after the pleadings, after litis contestatio, 30 days, send a notice who you're going to call to prove your claim. So you're going to call an orthopedic surgeon who's going to say how the leg was broken. Then your claim is for pain and suffering. So the orthopedic surgeon will say it must have been painful. He's going to need so many operations. Yes, is there a question? The orthopedic surgeon will say what operations he's going to need. He's got screws, or when it must be removed, how painful it will be, right? So that would be your first expert. If you're going to claim for general damages, you will also need another expert, occupational therapist, who will do some tests with the witnesses. Can they walk? What distance do they walk? Can they carry things? Can they sit down? Can they stand up? All of those kind of things they do with a witness now pertaining to the injury, and they will tell the court that. So you would have to send that also before 60 days after the close of pleadings. Then you would then need, what else? If the person, because of the injury, now have psychological problems, then you must send a psychologist report also. So you must get the psychologist expert also. So you would send a notice of that witness as well. And then if the person lost employment because of the injury, then you must get a industrial psychologist, send a notice of who's the industrial psychologist. And he will make a report to say, can the person work, or what work can the person do, and is it possible for the person to still be employed or not? Is somebody speaking?
Yeah.
Janus.
Apologies.
Yeah. And yeah, and then an actuary will work out these specific amounts. So there's a lot of experts involved in one kind of matter of different disciplines. And if the defendant then wants to counter those experts, they send out an expert, a notice of what they are going to call in that similar discipline. These experts then get together, not all of them, the two orthopedic surgeons of either side get together, and they make a joint minute where they say how far they agree and to what extent they disagree. And the joint minute is also filed, right? And then the two occupational therapists, if there are two, come together. The court actually wants, for one case, that people must not, each party must not have their own expert. The court say that you can see 9 capital A, I've got it on there, second last paragraph. Parties should endeavor to appoint a single joint expert. But parties don't do that. You get plaintiff's experts and you get defendant's expert. They don't want to have one expert. The purpose of an expert is really to assist the court by giving an objective opinion of the injuries and the consequences of that injuries. That is what the whole purpose is. But in practice, for those of you who know, you will see that these plaintiffs experts who will say the person because injury will never be able to walk 100 meters in his life. And then the defendant expert will say, if it takes 2 Panadas, he can run a marathon. So they will be so diverse in their opinions that to have one witness as they want, the rule board want them to have one witness, the court would like them to have one witness. It doesn't work like that in practice. We still have 2. They come together and they do a joint minute. Now, in the joint minute, they will indicate they come together. I mean, they phone each other or they email each other, and then they will compile a joint minute. In the joint minute, they will indicate how far they agree with each other, and then they will also indicate on what specific aspect of that injury do they disagree. And then the court knows only that is an issue. In a lot of cases, the experts then in the joint minute, they come together and they change, some of them change their minds after they've spoken to somebody in the same profession as they change and they come together and they tell you, this is the injuries, this is what happens. Yeah. So that is as far as that. For a joint minute of experts relating to the same area of expertise within 20 days of last filing of such reports. Right. I just needed to tell you this. If a claim relates to an object, the object must be made available to the defendant to examine and to let these experts examine it. Likewise, as you now know, if it's a bodily injury, then the plaintiff must be available to be examined by the experts of the defendant. So the rule makes provision for must be sent, appointment must be made, and it must be agreed on, transport must be paid, and the person must then be brought to the expert so that the person can be examined, so that the expert can provide a report. The same with the claim relates to an object, say for example a motor vehicle that malfunctioned. That motor vehicle must be brought to the expert, or the expert must be given access to the motor vehicle wherever it is, so that he can go and examine the car and tell you what he thinks is wrong and caused whatever damages was caused. So just remember that. Yeah. Are there any questions on Rule 36? So you will send a notice in terms of the rule. Now, a notice in terms of the rule, a tip for you, use it, don't use it. I'm just going to say it for people who want to use it. If you are ever asked to do a notice in terms of a rule and you do not have a precedent, follow the wording of the rule, right? Make it sound logical. So you would say in the tram lines, you would have the heading and you will say in the tram lines in terms of Rule 36(9) or A or B, whatever. And then you would follow what is in the rules. The rule maybe say, let me see what Rule 36 say. The rules say, where the plaintiff intends to call an expert, the plaintiff shall not more than 30 days after the close of pleadings. So you will follow, you will just say, be pleased to take note intends to call the expert and the name. You would follow the wording of the rules. And if there's somebody, this is just a simple one, this you don't even have to look at the rule to comply with it. But if you do serve a notice in terms of the rule, look at the rule and don't now copy and paste the rule and leave it like that. Let it sound logical. Say, be pleased to take notice that you are required, and then follow the wording of the rules, and then your notice cannot be wrong. It is in terms of that rule. It contains everything that is in that rule, and it makes logical sense. That is the best way to draft independently without precedence. And you know it's right. Nobody can say it's wrong. And in the tramline, it will just say rule in terms of notice in terms of rule 23, or notice in terms of rule 35(1), or notice in terms of rule 36. Follow that wording, it is signed, and that's that. Okay, that was my bit of information. You can, before the trial, you can ask for, that page reference is incorrect. You can ask for further particulars for trial in terms of rule 21(2), where you ask the opponent to give you further particulars so that you can prepare for trial. So this is particulars that is not included in the pleadings, but from the pleadings, you will need this. What people do, say if it's a loss of income claim, and the person has presented pay slips or bank statements, but or he says he done a certain job, but it's not, he's self-employed, right? There's no proof, but this is what he say. His salary was 20,000 a month, self-employed. You can then what people would usually ask in the further particulars is, can you give us your last 5 years income tax returns so that we can see if you really earned this money? Yes, there's a hand up, 2 hands actually. Yes.
Yes, counsel. Sorry, just to get back to the notices. Advocate Abrams told us about a fact where you need to now attach the the CVs of your experts. Does one do that with the 36(9)A or with the 36(9)B?
It's usually with the 36(9)B. You don't have to give the CVs at this stage, but they usually would file it. And especially should the person not be known. They don't file it in each and every instance, but if the expertise is going to be challenged, then it's best to file it. It's usually with the second one, with the summary, but you can do it with the first one also, with the CV, because remember, if you are going to put your must first prove to the court that he is an expert. So you will go through his qualifications. You will say, what is your qualifications? Actually, you will tell the court why this is an expert. So you will say, this is what I've done. This is my qualifications, and this is the work that I've done. How many times did you testify as an expert? All of that you put on record, but it will be in the CV. So it can be with either one. There's not requirement that it is with the first notice. With the second notice, yeah, because you must prove that he's an expert. So it's good to have that already on record. And sometimes it's not challenged. Many times it's not challenged if experts, because experts are known for their expertise and they are regulars in court. I mean, if you read law reports on those, you'll see the same names of the same experts time and time again who gave evidence.
Thank you, counsel.
Yeah. Okay. Yes. Whose hand is that? Is that your hand?
It's fellow advocate.
Yes.
I wanted to find out with these road accident fund claims, when it comes to the joint minutes, when the actuaries, do they also do joint minutes and then decide whose report they're going to use for the court to order when it comes to the quantum?
If they're going to do a joint minute, then they're going to have a new calculations that includes the 2 different calculations. That is what the joint minute is for. And as far as they agree, but if they're not in agreement with any of the things, then they would say on what they do not agree. And then it's the court don't just use one. If the parties don't agree, then the court must hear the evidence and the court must decide which evidence is going to accept and why, and which evidence is going to reject and why. So then it's for the court to decide. So you will call both experts, both parties will call their experts, and both will give evidence. They will be cross-examined, and the court will decide what expert is going to follow.
All right, thank
That's
you.
how it works. Okay. If there's only one expert in a specific discipline, then that is the only expert evidence that is before the court. You can challenge it by cross-examining, but if you don't have an expert to counter it, you can basically just challenge it, maybe basis on which the evidence is based. Because remember, an expert witness consults with the client. Say it's a plaintiff, bodily injuries, will consult with the plaintiff. The plaintiff says to him that, look, I can't sleep on my right side because of my leg injury. I must sleep on my left side. Or he says whatever facts he say, he will base his expert opinion on what he hears. So in that case, if you don't have an expert in the same discipline, the only way that I think you could attack, or one of the ways in which I think you could attack, is that his opinion is not based on the truth, because you would have tried to minimize or to test the credibility of the lay witness and make it him or her to not be truthful. And then you will tell the expert, but this person that told you that is not telling you the truth, because the occupational therapist said they can do X, Y, and Z with the test they have done. You would know all the facts and all the reports, and you would bring it in. But usually, if there's only one expert in a specific discipline, his expert report prevails. Yeah, you can only counter his expert opinion if it's based on the correct facts with another expert. And if you don't have another expert, you can ask the court not to believe it, but based on what? You must place evidence before the court. Okay.
Sorry,
Yeah, I'm thinking
Advocate.
aloud. Yes.
So these experts, particularly in these RAF matters, because I know of someone who went to go see a neurosurgeon and they got there and behaved like they're crazy, and then they were declared to have some mental illness going on, and a curator had to be appointed, whereas that's not the case. So don't these experts assess them thoroughly, or they just take what they see in fact before them and how the people behave and what they're told?
But how can people objectively see if that you are crazy? You can act crazy, but how can they see that you are acting? Okay, some of them will say that it looks like he was malingering. You will read in some reports that people they caught on that this person was lying or whatever. But they I say you would then challenge it from that aspect by saying the basis on which your opinion, I'm not disagreeing with your opinion, it is an expert opinion, but the facts on which you base it, I will try and then prove that wrong. I don't know, you say the person wasn't crazy, acted crazy, and the expert believed
No, they
him.
were not. Yeah, it was that thing of
But how can
saying.
an expert say this person is not crazy if he acts crazy the whole time?
Yeah, that's what I'm saying. That so they basically look at what they see and then they say this is how they assess the person to be.
Yeah, that is why it's good to have a lot of experts. I know a lot of especially occupational therapists, they say their office is such that they look at the parking lot. So the person comes to the and the person can't walk properly and when the person goes to the car from over the park, they run, and then they write that in their report. So there's other ways and means also for them to, I mean, he could have looked at other experts and see how the person behaved there and whether the person was they could do that. I don't know.
Just to interject, Advocate, in practice, I've seen that the experts would protect themselves and say that at the time when I assessed the accused, this and this is what I found, so they confine it to a specific period.
Yeah, because and they say it may change if the circumstances or if other facts come to light. They end it like that. Yeah, they say it may change if other facts come to light, because they must. It's just on and it's one way in which you can make inroads into whether you're not saying the expert is not correct. You're just saying it's based on incorrect information. Yeah. Yeah. Any further questions? We are past 8:30 now. If you have any further questions, you can ask them tomorrow night. Let's call it a day. See you tomorrow. We'll hear you tomorrow.
Advocate.
Okay.
Thanks, Advocate.
Thank you.
Bye.
Bye,
Good
Advocate.
night.
Thank
Thank you,
you.
Council. Have a good night.
Thank
Thank you, Council. Have a good night.
you too. Thank you. Okay.